Hey guys, and welcome to the weekly docket. Hey guys, and good morning. Let's see if I can all these things going here. Get the chat happening. All right. Well, I'm a little tired from last night with the debate with Nate on Joe's channel about the Trump indictment. Something I never wanted to have happen, but it did, and I enjoyed it. All right. Let's talk about some of the other criminal cases around the United States, because it's more than just that one. So let's start off with Richard Allen. I had that on the radar because the court had said it was going to unseal documents in the case, but I don't think that has happened yet. I'll show you what was on the docket that I found, and including as of this morning. And so the first is the order from the court to the people who have him in custody, saying that you can give any records regarding his mental health, etc., to his attorneys without any further order. That certainly makes sense. Then another order is indicating that the motion to suppress, and I'm sure that's on that round, that bullet that was found at the scene, that's continued because the defense needs to file errors and omissions. So some technical reason for them to continue that. And there's a temporary restraining order that was being argued to try and deal with recording at the prison, but the prison agreed and has apparently already stopped recording the visits between Richard Allen and his attorneys. They weren't recording audio, but I guess they had the cameras on, and the attorneys didn't like that, which that's reasonable. And it is under advisement, I suppose, in terms of where he's going to end up. So that's really all that's going on with him. If you want to find this, because you may find it before me when it actually happens, Indiana uses the same software as a lot of states do, the MyCase software. And so when the documents are available, I think it's even a different color. It has a little icon, and you can punch on it and bring it up. But there usually aren't so many in the criminal cases, but I figure that's where they're going to put it when they release it, because that's how they do in the civil cases and stuff. So maybe we'll see some of what they've got there in the near future. And that case is interesting. Again, we talked last week about his alleged confessions and what he said and who he said it to and under what circumstances and how many times he said it. It's going to matter a lot as to whether that's compelling or not. But I can tell you that if you're his attorney, you wish he were not confessing. Here's a comment related to when I was talking about the stream last night. Did I get the short straw? Well, I can tell you that earlier in the day, I was hoping somebody who was more familiar with it would pick that up. Plus, I don't like talking about that case as a concept, or cases like that, the Trump thing. But I did enjoy, and I knew I would, talking with Nate and with Joe, so that's fine. And I did some research on it, despite the prevalent view that you can just instantly know whether he's slam dunk guilty or he's instantly innocent. The law is generally pretty complicated, and it certainly is complicated in the case when you're charging the former chief executive of the country. It's whether you think he did something wrong or not. The law surrounding it is murky because it's almost unprecedented, and then it gets deep into some issues. So it can be interesting, as long as everybody's not bringing pitchforks out against each other. All right, let's get back to this topic. And Texas here too is the comment from Marsha Lynn. I was talking to Nate about that because he moved to Houston, which is a city I never bonded with because it's so gigantic. It's just huge, and it has a lot of humidity like here, maybe worse. Anyway, let's go out west a little bit, but let's head up north where the humidity is not so bad and talk about the Bryan Kohberger situation. So I wanted to put this in here, even though I did a little live stream on this. I'm pulling this out of that to make it clear what was revealed in the latest state finding that I think is so relevant to this case. Pursuant to a search warrant, okay, they didn't just sneak in and get this, law enforcement collected DNA from the defendant, Bryan Kohberger. So his personal DNA, not a family tree thing, not his father or whatever, his own individual sample. And then a traditional STR DNA comparison was done between that profile and that found on the K-bar knife sheath. So they compared Kohberger's DNA personally, his personal DNA, to what was found on the knife sheath. That comparison showed a statistical match of at least 5.37 octillion times more likely to be seen if Kohberger is the source than if an unrelated individual randomly selected from the general population is the source. So I think as far as you can say DNA is a match, that's a match. That STR test was done by the Idaho State Lab. The other kind of profile that was done by the FBI, which was used to compare to his family tree. And that's how they helped develop a lead on this guy, kind of like looking at what kind of car he had and stuff like that. But the actual evidence they're going to use in court to say that the DNA at the crime scene matches Kohberger is this. And it's what was done inside the state lab. So that's interesting. It's two different things. Because as we talked about, the defense wants all the information related to the lead up to the family tree and then the match. And then the state is saying, look, we're not going to use that as evidence. That's not what shows whether he was at the crime scene or not. It's whether somebody from his general family was there. What matters is the comparison of his personal DNA to that found at the crime scene. And that they are turning over or have turned over all of that. Nevertheless, I checked this morning and it was too late to put it in the slide. The defense has calendared the motion to compel, their second motion to compel, and that's going to be next week. And because it's at short notice, the court is letting the family come in by Zoom, which is good, I think, in case they can't come make it live, travel plans and stuff. So I took a quick glance at that, and the second motion to compel had a lot in it about, any videotapes and how videotapes of the car and stuff like that, and a few other things. So I'm not sure what they're thinking they didn't get, but that's what it'll be about. So I got to punch this one. Good afternoon from Scotland. That's the place my wife wants to go the most. Thanks, Outlander. All I ever heard was Scotland, Scotland, Scotland. And then I told her, look, it's coming to North Carolina. And she totally thought I was making that up. And then the show came to North Carolina and is based out of North Carolina. So, but we're already in North Carolina. So what are you going to do? And we have a lot of Scottish people here, but I'm not one of them. All right. Thanks for that comment. Let's go over to this case, because this is a sad and weird and bad one. And that's Kouri Richins. She's on trial for murder of her husband. She wrote a book about it, and that got this on the news, about the grief of losing this family member. She tried to navigate with her sons the sudden loss of their father. That's an issue if you are the one who murdered the father. Otherwise, it'd be a heartwarming thing, right? It kind of goes the opposite way if you're the one who murdered him. But way to complete the circle, right? To take care of everything. You not only murdered him, but then you also wanted to help deal with the grief after and help other people do that. So she certainly has a unique perspective on that, being potentially the killer herself. Well, she has filed suit against her husband's estate for money, because that's why you sue estates generally. And they do have a slayer statute there in Utah, which basically says, look, if you kill the person, you can't be inheriting their money. And it doesn't, I think, require criminal conviction to stop that from happening. The estate can challenge it, and they can have a hearing on it. They can get a restraining or like a delay in the proceedings and things like that. But she's not just asking, although she does ask as the widow, I need this money, bro. She also wants what she says was her independent share of assets that would be commonly owned. And that's a better case there, because I'm not sure that you forfeit your own property in this slayer statute as much as you're forfeiting the right to get the money of the other person. So maybe she'll get some money out of this, and she's going to need it if she wants to avoid having a public defense and wants to have a retained attorney. She's going to have some cash. They did catch her talking to her mother. I guess she was in jail at this time. That the only person she's a danger to now is her husband's sister, because she's representing the estate. And apparently Kouri laughed, said, ha, yeah. So great job, Mom, joking about being a danger to people while your daughter's in jail on trial for murder. I think the defense team probably has had a talk with her about that's not hilarious, and it was actually used to show that she remains a danger to other people. So she allegedly said, I want the Michael Jackson stuff to take care of her husband and take him out of the game. And I'm going to quote this piece here. She had a second iPhone. Okay, that's usually not good news unless the first one is work issued. The device allegedly contained highly suspicious internet searches. Whose doesn't? But again, the issue is this is her second phone, including one about what a lethal fentanyl dose is. Luxury prisons for the rich in America. Women Utah prison. Can cops force you to do a lie detector test? Death certificate says pending. Will life insurance still pay? FBI analysis of electronics and investigation. When does the FBI get involved in the case? How long does life insurance companies take to pay? And shout out to her for, I see the period between take to pay. Every time I'm searching on my iPhone, I always get a period instead of a space. So they need to fix that. How to permanently delete information from an iPhone remotely. Ah, that's nice. And what is a lethal dose of fentanyl? So, you know, if I'm looking at a case, I might have some weird internet searches myself, but this seems extremely specific to this situation, doesn't it? So, yeah, we'll have to watch this a little bit because just a bizarre set of circumstances. But she appeared to, of course, show no real indication of sadness. She definitely is an expert on getting over grief because she did it quickly, having a party at the house the next day after he died and things like that. So, all right, let's pop this up here because I just saw this. Here's a comment, and I'm reading these comments because somebody said, dude, if you don't read the comments and you just reply to them, how am I supposed to know what you're talking about? Which is a great point. Her second book is called How to Put Daddy to Sleep Forever. Yes. And her third book will probably be Don't Search Things on Your Second iPhone If You're Going to Murder Your Husband. She has a whole series of books she can do, and she probably will have the time to do them. I think her future schedule is going to be light on outside work and more on hanging around the cell. All right, let's go into this poll vault for this latest poll we did. Not the latest because that was a guy in a ski mask, but the one before that. And that's the circumstantial and direct evidence poll. That this thing got almost 700 votes. So that's interesting to me that people would find that much interest in this kind of topic. But it's cool though. I like it. So here was the question I put up, which it has some ambiguity in it and stuff like that. But I think we kind of knew what we were trying to achieve with it. The murder weapon is recovered at the scene of the crime. Lab results find one DNA profile on the weapon, and it belongs to the defendant. Is this DNA evidence direct or circumstantial? And I've asked two people that I know in the last day, and they both said direct, which mirrors the predominant result in this poll, 63%, 31% saying it's circumstantial, 5% I don't know, which is always a good answer. So 2-to-1, people say it's direct evidence. But what is the right answer? So before we, pull the curtain down and show it, I want to say one type of evidence is not inherently better than the other. Direct evidence is not better than circumstantial evidence and vice versa. And either can be more compelling than the other. And I think that'll make sense some. And let me say this before we get down into the legal minutia. If you hear this and you think, oh, well, I thought I was right, it was wrong or whatever, it's more important to me, of course, that you think logically. So to me, the 61% direct, 30% circumstantial, from all the comments I saw, everybody's process was logical. So that's 95% good thinking. And it kind of doesn't matter what the law calls it, because the law will tell you, if you're on the jury, it doesn't matter whether it's direct or circumstantial evidence per se, because you as the jury have to decide for each piece of evidence how compelling it is, and the whole plethora of evidence, all of it taken together, whether it establishes a fact beyond a reasonable doubt or not. That's for the jury to do, to give the weight to. The law doesn't do that. So here's a potential jury instruction. I put the one from North Carolina in the comments, but this is from another jurisdiction. Evidence may be direct or circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, you need another fact to prove it, right? So you are to consider both direct and circumstantial evidence. Either can be used to prove any fact. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. Let's dig into that a little more. The basic distinction is this. Direct evidence is evidence that directly, if it's credited, proves a fact necessary for guilt. So an eyewitness says, I was there. I was 3 feet away and I saw that guy stabbing that other guy. I saw that. Well, that's direct evidence. And that's perhaps pretty compelling. Now, if I say, I staggered out of the bar drunk and I saw this dude stabbing this other dude and they were like over in that alley and it's dark, but I'm pretty sure it was this guy, it gets less compelling. I mean, you might believe I saw the crime, but the identity as to whether the defendant did it or not, I'm getting a little shakier there. So direct evidence can be extremely compelling or less compelling. Circumstantial evidence requires an inference. Okay. A car seen going to the scene. So like in the Kohberger case, they have video of his car leaving his apartment complex late at night and then coming back later. And in the duration of time between his leaving and coming back, the murders occur. That's circumstantial evidence. It doesn't mean that he committed the crime, but it's part of the chain of evidence. And more directly to that, the DNA evidence on the knife sheath. That's circumstantial evidence because it doesn't directly show that he stabbed these people. Okay. So it's found there and it is very compelling evidence. It's very compelling. But as some people pointed out in comments, hypothetically, he might have sold that sheath that morning to someone else who wore gloves with it all day. And that's why his DNA is on it or whatever. Somebody stole it from him. So those may be unlikely, but they could be true. So you don't have a direct line from we've got his DNA on this knife sheath to he was the one doing the stabbing. You have to look at other facts surrounding it. Now, in my opinion, when you take the other circumstantial evidence and look at it, the car, the phone, the this, the that, and the other, and things we probably don't even know about yet, but even what we know about it, I think it's very compelling. And the DNA evidence is highly compelling circumstantial evidence. Now consider the direct evidence in the case. There was a survivor who saw somebody. I mean, if it was Kohberger, that's who she saw. She saw who the killer was, the person who was unauthorized in their home, dressed up this way, leaving the scene. Didn't see the stabbing, but, heard it and all that stuff. So she's a witness to the person being in the house and then leaving the scene. That's right on the border of direct, indirect, or circumstantial. But the point is, she's probably, it appears, not able to identify the actual person, probably due to shock. And I don't know what her state of mind was at that time. And the person was wearing a mask and only revealed their eyes. So to me, the circumstantial evidence here is going to be critically important. And it can work the other way too, right? Because if they looked at the car and Kohberger's phone and stuff like that, but then they find the murder weapon at the scene and it has one person's DNA on it and it's someone else, then it points hard away from Kohberger, and you'd have to be looking at the reverse scenario. He's probably innocent unless he's the one who did the stealing and wearing gloves and stuff like that. So I think sometimes, well, let me read this before I get to the summary, because this is a pretty good example about it. Got this off somebody's page. For example, California courts instruct juries that before, this is called a circumstantial evidence instruction, and it kind of gets to the difference between I saw that guy stab that guy and the mental process you need to use circumstantial evidence. Not that it's weaker, but just a different mental process. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. But when considering circumstantial evidence, you must accept only reasonable conclusions. Here they're dunking on the eagle of innocence, and reject any that are unreasonable. And they give an example. Larry offers a reasonable alternate explanation for his blood-soaked clothes. Then the jury needs to accept it. But if Larry says, why did I have 5 pints of blood all over my clothes? Well, I cut myself shaving. Look at this tiny cut. You don't have to accept that. So it's not, for circumstantial evidence, it's not what all can you fantasize, aliens and ninjas and stuff like that. It has to be some kind of reasonable alternate explanation. So if Kohberger were able to defeat, say, using him as an example, the circumstantial evidence by saying, well, I sold that knife. Here's a receipt for it. Here's the guy who bought it. It probably did have my DNA on it, but he can say, prove that he sold it to the guy. Maybe even took a picture of himself selling it to the guy. Well, that would put a big hole in that DNA evidence, wouldn't it? So you'd have two reasonable competing theories there. And in that case, you're not really beyond a reasonable doubt. But that's a lot of work for the defense to do, but that's kind of your mental process for circumstantial evidence is does the circumstantial evidence add up to the most reasonable explanation, being that the state's theory that these facts are true beyond a reasonable doubt, that's it, and that any other explanation for the circumstantial evidence is not reasonable. It can't be aliens and stuff like that. But maybe we'll come back to that point later this year because maybe there are aliens. So I should probably stop using that example. So that's the legal view of how to apply the label of evidence. And sometimes in the law, even in some decisions, it's applied inexactly. So a lot of people did figure it out. But again, as I think I was going to say, some people view direct evidence as high confidence evidence, like a high quality DNA match or a camera. And circumstantial stuff is, well, it sure does look like it could be that person. And that's a good common sense way to look at it. And I often hear lawyers refer to a case that way when they're talking about circumstantial case. But when you are talking about how to label the evidence in the mental process, that's the difference between direct and circumstantial evidence. Direct evidence is, if I look out this window right now and it's raining, I see it raining and I testify to you it's raining. That's direct evidence that it's raining or has rained during this day. If I look out there this morning and the whole place is dry and I go inside for a little while and look back out the window and everything is wet, that's circumstantial evidence that it has rained. Okay, so that's the difference. Could aliens have sprinkled water all over my property? They could have. That's a less and potentially not reasonable way to view it differently. So let me see some of these comments here. Because I see one that says, do they inform the jury of this? And I'm not sure, because I was talking so much, I missed a lot of these to know what your question is. Let's see. This says, in Scotland, it's wet and miserable, just waiting on the thunder. That's good news for my wife because it's also wet and miserable here, but it's humid and warm. But we can pretend we're in Scotland at least. The Kouri Richins trial will be interesting. Yeah, I think it will be. Let's keep going here. Let's see if we could cover up any questions here. I kind of weather, love rain and thunderstorms. I love it too, even the rain. I don't like thunderstorms if I'm staying outside, but I certainly like the rain. All right. So are we going to talk about the idiot Melly? I haven't really been watching that case. I just posted that shot yesterday of the guy with the mask on testifying because I thought it hit right on the point about what we were talking about, the confrontation clause, which is interesting. Now, if everybody wants a virtual law degree like sometimes people do with the simplest thing that you can possibly say that is generally accurate, you can just say, it depends. Because, for example, the guy with the mask on, is that going to be ruled a violation of his rights? It depends. Now, I think it is a problem that two jurors said, hey, this is bugging us, right? Because the jurors need to be able to weigh the evidence, and treating a witness differently like that could be an issue. Then, on the other hand, cases have said that the judge runs a courtroom and determines witness security. And if the judge finds that it's necessary for witness safety, the judge can impede and impose some on the defendant's rights in this balance. You can't just do it for the heck of it, but sometimes they will let them do that. But I didn't find the mask cases at the appellate level. What I found was generally, like they had a case here in federal court in North Carolina where they let the guy wear a wig and a fake mustache, and the judge said, and it kicked everybody out of the courtroom that didn't need to be there, and said that way the jury will still be able to see the facial expressions and other things that are generally considered important for a jury to be able to evaluate in terms of credibility. So that's going to be tougher to do when you're wearing a ski mask, but it depends. That's always the answer. And, even though we debated for 3 hours last night on Joe's channel, and a lot of people are like, it's so obvious it's this, and then other people are like, it's so obvious it's the other side, it might want to pause for a second and think, maybe it's not so obvious. Law can be quite complicated, and people are complicated. They do weird things. No matter how many laws you come up with, people find some way eventually to do something unusual. And then you just have to extend the law by analogy and reason and thinking and fall back on, it depends. Because if I give a concrete answer a lot of times on something to try and move a point along, I will get hit by somebody somewhere going, but you didn't mention this exception. And that's a fair point because there often are exceptions. Let's see. So I'm unfamiliar with the ID case. What kind of mask? Is it a robbery gone wrong? Well, the one that I posted yesterday was this Mellie case, and the witness is an undercover police officer, so they want to have him wearing a mask so it hides his identity to people that may not like undercover police officers. Okay. And I think, why did jurors need to see the defendant? Maybe they do, maybe they don't, right? But generally speaking, the defendant has a right to be in the courtroom because the defendant's on trial for their freedom. So they should be able to be there. Now I'm talking about from the defendant's perspective. Why does the jury need to be able to see them? If the defendant is removed from the courtroom, or you do weird things to the defendant, like tape them up and gag them, and you don't need to be doing it, you are sending a message to the jury there that there's something going on with this person. And the idea is you don't want to treat witnesses or parties in such a way that creates a perception of bias for the jury. So you'll see them try to avoid that a lot of times in trials, where they'll put the curtain around the table so that you can't see that the person's shackled to the ground, even though the jury probably figures it out. That's what they're trying to do. Or put a suit on somebody that's never worn a suit before and is actually incarcerated. So that's fair. The name of the channel I was on last night is Good Logic. Okay, so that's Joe's channel. And he streams late at night and didn't start till 10. I had a candle in this thing, and it by the time we finished, the whole candle was gone. So it was a long one. And it was all about the Trump indictment, not the topic I was most excited about. Anything new on the Courtney Clinty case? I haven't looked lately. I looked at the civil case too for a bit there for the estate of the victim against the various parties, security company and the condo and all that stuff, which I wasn't impressed by that personally. But on her case, I just haven't looked lately. So that's it. So if anybody wants to, who has asked, because some people have, are you going to talk about this Trump indictment on the federal level? I didn't really want to. I didn't get a good reaction to the first video I did to it. And I think people have their opinions on it. But what Nate and I did try to do was, not doing whataboutism, but actually talk about the legal elements involved in the case. So that's what we did. And it was very interesting, and I enjoyed it. And I will say that Nate, before we got live, he was on there. He's very sick, and he didn't cancel because he wanted to be able to present this other side of it. And I mean, you can't have a debate if you don't have the other side of it. So I also appreciate him doing that. He was on mute a lot because he was coughing and stuff. Is Sarah Boone trial going to go ahead, or will it be delayed again? The last I looked, which was really recent, I hadn't seen anything else. Now, it wouldn't surprise me if it does get delayed again, but nothing has happened yet. Did she find a witness who's going to say she was a battered partner? And if she didn't, is she going to continue the case until she does? If the judge will let her, I don't know the answer to that. There's no further letter from her in the file, which I guess suggests that she's content at this point, at least with what's going on. And apparently they did come into a hearing at some point and discuss this letter because, the judge checked the box that says this was discussed in open court. That's the responses that she does get. And last news, I guess, is, I pulled up the federal lawsuit from a few years ago on the Ocean Gate situation with the little submersible that imploded, it appears, while it was visiting the Titanic, because I had heard, they were sued for safety things and stuff. And well, why not go to the original source? So that's what we did, right? We went to the original source, which was the lawsuit, because that's where the people are getting this information from, and read what the guy actually said. And it didn't sound good in the counterclaim that he's saying he was fired in part because he wanted them to do testing on the hull to check its integrity between dives instead of relying on a real-time monitoring that he said that's going to tell you when it's about to break, and that's when you're going to be 3,000 meters underwater, and it's too late to find out then. So I had some offline discussions with my brother about this because he's a materials engineer, and he's involved and knows about acoustic testing, non-destructive testing. And I don't have experience in that area, just visual testing on metals. So they should have found a way to do that. So that's really unfortunate that happened. That case, though, the federal case was a civil case, and it's settled. So we don't know who paid who in that case, or really what happened. But OceanGate was suing the guy first, saying he was disclosing things and stuff like that. So he's made a lot of comments to CEO. Of course, he's dead now, so I'm sorry for him for that. But he certainly appeared to have an attitude that was highly reckless. Sometimes that's what it takes to do extraordinary things, but sometimes it also just makes a hobby more dangerous than it needs to be. And carbon fiber for a hull for something like that, this, I think, is the first time somebody's tried it. Maybe it's going to be the last. All right, so I don't see any more questions, so that'll be that for the criminal stuff. And I will say to the people who have joined the channel to get into more deep stuff, after I log off of this, I'm going to put the poll out to see what you want to do for a member stream next week. If anybody wants to join in on that, now's the time to do it. If you don't want to, that's okay too, because I'm not going to change how I'm doing this channel. But there are some weirdo things that, some particular things that I think, not in a public forum, but more with people who are directly interested, it would be kind of cool to discuss. So I'm going to do that after this is over. Let's see. I think I am out of slides and out of questions. And I appreciate you guys coming in. And I hope you have a good weekend. And we'll talk to you later. And thanks. Bye.